This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviat. Tonight we're taking your calls and questions all about family law, so divorce, child custody. If you're going through that or you're thinking about it and you have questions, call in the 31 Law Call number 256-536-0077. You can also now text to that same number if you're a little shy or you don't want your ex or your current to hear your questions. You can also email a question any day of the week. You can send it to lawcall@waytv.com, and when we get to a show that's on point, we'll pull some of those out. And we've got some of your email questions tonight. Getting us started tonight, Will League is here from Timberlake League and Brooks. You guys do personal injury cases.
Sharon, we're talking about, I won't say it's your favorite topic, but it's your topic.
It's my topic.
Yeah, so it's your expertise.
Yes.
So maybe not your favorite.
Well, it's always exciting.
Right.
People come into my office and I say, please tell me when I haven't heard. Tell me something new.
That's right. That's right. Y'all, in y'all's world, it's so difficult. We got divorce, child custody. Who gets the children? Who's paying child support? What happens if he or she doesn't pay child support? So if you're mad at your ex or mad at your ex's significant other, have questions, we had experts tonight to talk about that, how that relates into any personal injury world that we handle. We'll chime in on that as well. But if you've got any questions, give us a buzz, 536-0077. We got a couple of experts here.
And you can also text to that number too. While they're locking in some phone calls, we always like to give you a video. You make the law call. We pull this off of YouTube. Well, something's about to happen here. So, didn't need that air conditioner at all, did we? We've got a couple of different views of this. It looks like this bridge is marked with the height and everything. When you look at this as a personal injury attorney, and what are you seeing? What are your questions with this?
You make the call. It looks like he blew it. I mean, there's clearly a sign that says 12-4, so average is 14 to 16 in the Department of Transportation, but state and local don't have to follow those regs. So it's on that driver to check that sign. 12 feet 4 inches, know how high his rig is or her rig is. And, if they're renting that, they're on the hook to get it paid, to get it repaired. Looks like it's a tow behind. Maybe they're renting, maybe they're not, but they got some damage, and they may have to pay for any damage to the bridge if they cause that. So, you've got collision and liability. Collision would cover that if you have that type of coverage. That's my call. What do you think, Sharon? You think he blew it?
I think they forgot the air conditioner on top. I think they knew how tall it was, but then they've added something new. And I
agree.
That's going to have some major repairs.
That's our call. Sharon, we've got another expert in your world.
Yep.
We sure do. We've got Alexis Killo from Cove Family Law. Now, Alexis, you practice out of Hampton Cove, Alabama, but mostly all around North Alabama. Is that correct?
That's right. I am in Madison County, Limestone County, Morgan County, anywhere kind of in the general Huntsville metro, depending on where I'm needed. Okay.
And like me, you clerked for a circuit court judge for a few years before you went out in your private practice. Is that correct?
I did. I am one of the esteemed group of Judge Smith clerks. We're kind of a little bit of a posse up here in the Huntsville area, but I spent a couple of years with him learning the ins and outs of how a courtroom works and what it's actually like to be an attorney.
Yeah, wonderful learning tool. When you were in there, did you decide what type of law? Because you see all types of cases. What made you travel towards this area of the law?
Honestly, family law fell into my lap. I am of the group that had, career changes and life changes during COVID.
Right.
And a family law job fell into my lap, and it turns out I really enjoy it. Okay. And so I've stuck with it.
We talked about some of the things we wish people knew. People call and things that they assume they know. One of the things that family law attorneys get a lot of times, when can my child decide which which household they want to live with? He just turned 12. Can he decide for himself?
Well, and you hit the nail on the head. If we had $1 for every time we get asked this in this practice, and there's no magic age, there's no magic number. The idea that a child can decide where they live is a common misconception. It's one we hear a lot, but it's not based in the law. A judge is going to look at the total factors surrounding where that child lives and who they live with, and a judge is going to make that decision. They may listen to the child, they may take that into account, but there's no point where the kid can say, I want to live with mom or I want to live with dad. It's always up to the judge.
And how that enters our world is oftentimes if, let's say, the child's injured in some way, medical malpractice, anything, and who gets to drive the lawsuit? Let's say, God forbid, it's a death. And so the custodial parent usually has the right to make that, because you have to set up an estate, and really the personal representative of the estate makes that claim up for a death case. For an injury, the custodial parent. Now, my question for you guys is that the law or the judges shall, I believe, consider joint custody. Is that correct?
They are supposed to start with that. The current state is they should start with doing joint custody, and if they think that these parents can pull that off and cooperate and co-parent, then let's go with joint custody, and that is generally equal time. It may be week on, week off. It may be 2 days alternating weekends. That's what they try for. A lot of families just can't do it. A lot of divorcing people just can't make it happen.
Now, there's maybe social, religion, education, you know, extracurricular activities, things like that I've seen that are even in a joint scenario,
right?
That one parent is always designated, because oftentimes they cannot agree. Is that correct?
They don't want parents coming back, and they know that if they don't assign decision making, that's what you're talking about, that these folks are going to come right back. If we say you've got equal decision making, things won't get decided. So the areas he's talking about is parenting plan, right?
That's right. There are two kinds of custody that we talk about. There's the legal custody, which is what you are referring to. That's the who gets to decide what pediatrician the child sees, whether or not they get braces, what kind of church they go to, or if they're baptized. Those are the kind of legal decision-making powers that parents make. Usually those are divided and split into those categories. What most people think of as custody is what we call physical custody. That is, where is the child located? Who has the care, the physical custody and control of the child at any given time, which is also where we start with joint, but that's where most people, I think, run into problems, and it's not feasible for most people most of the time, I think, to maintain joint custody, because that requires a lot of working together for a divorced couple.
Yeah. Obviously, I mean, it's best for the child, for both parents to be involved and engaged and feel part of the process and things like that. So I'm guessing that's why the law says, hey, let's at least consider that first before we start venturing for one parent or the other.
Unless a parent has really been terrible, both parents are going to be involved in this child's life. Even if one gets primary or sole custody and the other one is getting the standard visitation schedule. In Madison County, the standard visitation schedule is a lot of time. It's about 40% of the time. So even if you're only getting getting standard visitation, it's still going to be a lot of time. Both parents are going to be involved. We've got callers waiting. We've got Andrea with a question from Union Grove. Hi, Andrea. Thanks for calling. What's your question tonight?
Me and my ex adopted a child, and I was taking care of my mother, and she had the job with the insurance and all that, so basically was adopted in her name, and I have no right to him. And is there anything that I can do to get any rights, because I'm the one that paid for the adoption?
Okay, so walk us through this again. So a child has been adopted, but basically it's your mom that adopted the child, is that right?
Oh no, my ex.
Sounds like she was taking care of her mother. Her and her ex adopted a child. You paid for it, but the paperwork was in your ex's name that you adopted a male child, correct?
Correct.
And because your name was on the paperwork, you don't have any actual visitation or rights to the child. Is that correct?
Well, my name's not on the paperwork. It was all done in her name because of the fact that she had the job with the insurance and all that. So everything was done in her name, but I'm the one that actually paid for everything.
Well, can you, I mean, because she paid for everything, I mean, does that get her anywhere, or does she have to be on that paperwork?
Chances are she's got to be on that paperwork. Without seeing it, it's hard to know exactly what the legal arrangement here was, but it sounds like if the adoption is complete, those are sealed and finalized pretty quickly thereafter. And absent a divorce or some action like that that would create a parental right or create a custody decision, I don't think she's likely to have any options to join or add in a parental right at this point. The law isn't usually concerned with who's paying for the action. The law is concerned with who's pursuing the action.
May I ask, was it a legal marriage? You guys, had your certificate and all that was set up?
No, at that time, it wasn't legal for us to marry.
Gotcha.
So, no.
Yeah, I mean, let me ask, so in a situation like that, okay, so she wasn't on, she says because of the insurance. So the other participant in the relationship had the job, had the insurance, it may, fly through customs a little better, for lack of a better word. They're married, but it's not a legal marriage. If it was a legal marriage, let me ask you this, Sharon, and Alexis, if it's a legal marriage, even though the other person adopted a child, you're married. I mean, I'm kind of thinking, once you get divorced, you have certain rights, or if there's a death of a spouse, you have certain rights. Do any of those kick in?
So I think it's going to be like being a step parent, and a step parent just doesn't have any rights. You may have gone and done a lot for that child, but if you're not the parent and you split up with the parent, you don't have any rights to that child. I think that you're going to be in that kind of situation.
Absent some formal adoption or some sort of designation.
Unless
like
they
that.
came back and did another adoption to allow this second parent to adopt the child, I think you'd have some difficulties there.
All right, last question. I know I'm beating a dead horse, but what if you file for some type of visitation because you had access to this child? We talked about grandparents' visitation rights, which are really, really tough these days. Mm-hmm. She had access. I mean, can someone off the street, and I get it, she's off the street, file for visitation for this child and the judge evaluate that, or there's nothing?
She would have no standing to file that. You have to have an established parental or familial right that's recognized under the law, and unfortunately, absent a step-parent adoption, a step-parent relationship, or I am dating a parent of a child that I've been very involved with, that just does not establish that right, so there is no standing. For better or for worse, there is no standing to file for custody in this situation.
If you got to the point where the parent who has adopted the child is an unfit parent, then anybody could come in and say they want custody of that child. But if it's a fit parent, I think we're in the same situation. It's like being a step parent, and once you split up, you don't have any rights to that child.
That's tough. That's tough.
Ann is on the line with a question from Coleman. Hi, Ann. Thanks for calling. What's your question tonight? Hi, Ann from Coleman. Yeah, go ahead.
I have a handicapped child.
Okay.
And my ex was ordered to pay support past the age of 19. He has not paid. He had a gap there between him drawing on his check, and he didn't draw, and then he started drawing on his daddy. But I kept a log of the amount of support and interest. He is now over $200,000 behind.
Woo, wow. Okay, so you had actual orders in place that said he was obligated to pay because it is a disabled child, a handicapped child, even beyond the age of 19. You had that order in place, and you still have that order in place, right?
Yes.
Okay.
It has not been released.
Okay, and that's very special.
That's a child support order,
It is,
correct?
and that's very special to go beyond 19.
Yes,
Never
it's
goes
rare.
away. No, I'm talking about back child support payments that never go away.
That's right. At the end of every month that child support is not paid, that child support payment or the amount owed takes the form of a judgment at the end of every single month, which means it is due and owing and collectible at that point. So there are options to file for contempt. That is probably the most common method to enforce these orders. You go to the judge and say, hey, I have a court order and it wasn't followed. Judge, can you help me enforce it? Can you help me collect on it? And I mean, all the way up to jail time, there are options to enforce or collect on court orders. And for this, a custody order, or sorry, a child support order at this point is no different than any other award that you would deal with as well.
Right. So it's okay. So I didn't realize. So each month, that's a separate order in itself, or contempt count.
Yes.
Okay.
Each month not paid is contempt. Each month not paid is judgment, and each month accrues its own interest.
Now, does DHR police that as well, or is it mostly your domestic attorney that you have?
So it depends on how the order was set up. Certain people have to pay through the state. And if they are paying through the state and through the child support office, then the state is tracking that, and the state often will help enforce it through DHR or through the prosecutor's office. If that is not paid through the state by the order, you usually need to speak with an attorney at least to get everything organized and to get set up into what that contempt will look like.
And they're telling us to take a break. We're going to come back and talk some more about collecting that money and what you can do on contempt. We'll take a break and be right back answering more questions about divorce and child custody.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi. And hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. Tonight we're talking about divorce, child custody, all these family law issues. Call in your question, 536-0077. You can also text to that number as well. We've got with us Alexis Killow. She is with Cove Family Law, and we've also got Will League from Timberlake, League & Brooks. They're personal injury attorneys, and you guys are doing something special for a nonprofit video giveaway. Talk to us about what that is.
We are. Visit our website. You know, we're doing for your nonprofit organization, nonprofit charity, we're doing a video, actually giveaway production worth $5,000. Hey, it ends tonight, so go on law-injury.com/blog. and enter in your favorite charitable organization, and maybe you guys can win that production. And you know, what entity and business couldn't use a little support like that? So we wanted to kind of reach out to the community, kind of see what we can do with that. We've had wonderful participation, a lot of good organizations, a lot of deserving organizations, and you know, give us a buzz, check us out, and maybe you can apply and win that.
Our last caller was talking about somebody being in contempt. Alexis, talk a little bit about what punishments there are out there for somebody that's in contempt, whether it's child support they're not paying or they're not paying their alimony. What can a judge do?
Sure. I mean, a judge can do pretty broadly whatever they see as fit in that situation. Most often we see monetary damages. So by that, they would have to pay the amount owed, and sometimes a punishment amount. A judge will add interest or sometimes extra even on top of that. If the situation is proper and if the judge sees fit, jail time can be an option in contempt. It can carry criminal penalties. Even I have seen judges just say, hey, go sit until you're willing to comply. It can be a little bit open-ended. It really can vary depending on the situation, but most of the time, money talks.
Collections is something that you deal with as well, right? You can win a big judgment or a big, did she say more than $100,000 in child support is owed? Collections, how do you collect the money if the person is not paying what they're supposed to?
You know, Alexa touched on it Alexis touched on it briefly about, you know, DHR, if you're paying through the state, they'll come and enforce. The district attorney, it's a violation there, so it can be criminally prosecuted. Also, your domestic attorney, but how it comes into my world, let's say I represent Jane Doe or John Doe, okay? We obtain a verdict or we have a settlement. In my world, I'll get served with a lien for either from DHR, from the domestic attorney, saying I represent John Doe and I recovered $500,000 for him in this 18-wheeler wreck. Well, before I can disperse John Doe's money to him, if I'm on notice of a lien, a valid lien, I may not transmit that money to my client until that lien is satisfied. So often we are dealing with DHR, we're dealing with prosecutors. Sometimes they'll take some of it, sometimes all of it, but oftentimes they'll work with you to what's fair to both sides. But again, if I'm on notice of a lien or financial interest on those particular funds, I may not pay out over that lien. For example, you know, Sharon, God forbid, you're in a car wreck. They rush you to the hospital. The hospital treats you. They have an automatic lien to any proceeds. So you come and hire our firm. If we win your case, we have to satisfy that lien.
For my medical bills.
For your medical bills before we can move forward.
Okay.
Same in child custody. If we're on notice of a lien in y'all's world, whether it be from a domestic attorney such as you guys, or a DHR, or the district attorney, we have to honor that lien. And so it's not unusual for you guys to write me a letter if the ex finds out
And they always
that Timberlake
find out.
Brooks is representing you. They think good things are going to happen maybe later, and they come around. They come around, Sharon.
They
So
do.
don't leave us
Somebody
alone.
shows up. Okay, we got this email question from Jonah. Jonah says, it is my understanding property bought in one person's name during a marriage is still marital property of both people. What about property bought prior to the marriage? Can you explain which is which? Talk about these different properties.
Sure. So, and again, this is a question we hear pretty often of, what do I have to split up? What do I have to share? What is mine? I feel like this is mine and I want to keep it. To lead with an example, the way we see this most often is, let's say I have a house that I'm living in, I get married. I move into my husband's house and we never live in the house I own. So house A is mine, I own it outright, but we never live there together. At first blush, that's separate property. It's mine and we're not using it for the marriage. Let's say, all right, I'm sitting on this house and I decide it's out there on Lake Gunnersville, beautiful house, got a great pool. I could make a killing with an Airbnb, so I start renting it out. We take that rent money, myself and my husband in this situation, and we use that to pay our vacations. It's our fun money, it's our play with money, and we both use the money that comes out of that Airbnb rental. At that point, that house is marital property. We've both benefited from it and used it, even though we're not living there. So we want to look at who's using the property, who's benefiting from the property, and who's gaining sort of the benefit of that ownership, regardless of whose name is on the paper.
So, I mean, to keep it separate, you got to really, really keep it separate. That's
Yes.
It's a good idea to talk to a lawyer. Prenups are not that expensive and can help you figure out a lot of things. That could have been something that would have been decided before the wedding. Especially folks who've been married before or who are a little older, do a prenup so it's crystal clear who's getting what if the marriage doesn't work out. We got this one from Joanna. Joanna wrote in, what are the options when a spouse keeps getting divorce papers? We'll find one thing to say he wants changed and then doesn't sign. I believe this is the third set now. I'm ready for this to be over. Sounds like she's talking about uncontested divorce papers. What's the problem?
Is there such a thing?
There can be. There can be
is.
uncontested divorces.
Okay.
There is, and they're probably more common than you would think. I would say over half of the divorces I do are truly uncontested. But to be an uncontested divorce, everyone has to have already agreed on absolutely every term. A domestic attorney like one of us, if we're doing an uncontested divorce, our role is usually limited to writing up paperwork, making sure everything is signed, and filing it. Anything beyond that, any negotiation or any issues with getting the other side to sign, that's not an uncontested anymore. To protect yourself, to protect your property rights, your parenting rights, anything that's tied up in this, you need to file a contested divorce. You need to file that complaint into court, the same you would with any other lawsuit, and that is going to set deadlines. The other side is going to have specific timelines that they have to answer in, and it'll open you up more options to push this process along absent an explicit and direct agreement.
Because when we send those uncontested papers, we usually put something in there. Please give us an idea within 14 days. Please sign and return within 14 days, but there's nothing official that they have to do that. They're telling us to take a break. We're going to take a break. Be right back answering more of your questions about family law. Stay with us. If you didn't get your questions answered tonight, here's how to get in touch with Alexa Killow with Cove Family Law in Huntsville, 256-297-3309. Also check out covefamilylaw.com. Here's how to get in touch with Will League with Timberlake League and Brooks. They are personal injury attorneys, so everything from car accidents to medical malpractice, 256-536-0770 or 800-804-2502. The website is law-injury.com, and if you like them on Facebook, you can learn more about the law that way.
And our own Sharon Doviet, family law attorney. Huntsville, Alabama, 256-539-7337, SharonFamilyLaw.com.
In our last second, somebody texted, says, what happens if you subpoena someone as a witness and they don't show up to court? What do you do?
You know, it's tough. Well, we subpoena witnesses just like you guys.
Yes.
You know, we can have them arrested. What do you guys do in your world?
You've actually been the one to sign some of these when you were clerking, right?
I have. We had this come up only once in the couple of years I was clerking, and it was probably one of my more exciting days as a clerk. I got to run around the courthouse really excited, but the judge can actually issue what we call an attachment order, and that attachment order gets handed to the sheriff, which now, right upstairs in the Madison County Courthouse, I was running some steps and heels, and the sheriff sent a deputy out to pick up that person and bring them straight to the courthouse.
And make them testify. So
Yes.
if you get subpoenaed, you better show up.
And it was pretty embarrassing for them.
Thanks for your questions tonight. We'll see you next week.